All right. Well, let's get started. Want to welcome everyone to our lunchtime discussion on things that are happening at the FTC regarding AI. I think originally this panel was billed as a discussion around the recent decision from the RITE AID settlement, but a lot has happened in the last few weeks at the FTC as it relates to artificial intelligence and what that means for companies and the supply chain. So I think we're just going to try to cover as much as we can in the next 30 minutes. I want to introduce our esteemed panel. We have with us Jon Leibowitz, former partner at Davis Polk and the former chairman of the FTC, appointed by President Barack Obama in 2009. During Jon's tenure, he focused on consumer protection, promoting competition in the pharmaceutical and technology sector, and internet data privacy. Prior to his leadership role at the FTC, Jon was an attorney in both the government and the private sector. We also have with us Maneesha Mithal, partner in the privacy and cybersecurity practice at Wilson Sonsini, where she advises clients on privacy, cybersecurity, and consumer protection matters, and represents companies in regulatory investigations. She is also one of the founding members of Wilson Sonsini's AI practice group. Maneesha also led the Division of Privacy and Identity Protection at the FTC and was a senior counsel at the Bureau of Consumer Protection. So welcome to you both. Like I said, we have a lot to cover. So, I think the first place to start with our discussion is, taking a step back and thinking about what the FTC can do with regards to, the emerging AI policy landscape. So, Jon, I'd really love to get some thoughts from you on, the primary mission of the FTC and how does that intersect with the proliferation of AI technology that we've seen?
It's a great question, Jon. So the FTC has two parts to its house. One part is consumer protection, and the other part is antitrust. But both parts of the FTC's mission are designed to prevent distortions in the marketplace by businesses that can harm consumers in a couple of different ways. So one is they want to stop anti-competitive behavior like monopolization or harmful mergers that increase prices and reduce choice. And the second thing they want to do is to stop things like false advertising or privacy or AI violations that prevent consumers from making informed choices or that result in fraud. I think I'll stop there. I know this is like a speed dating 30-minute panel, so I'm going to try to be quick and brief.
Yeah, and if I could just chime in, I think it's very interesting that the FTC seems like a natural regulator on AI, right? So what are the public policy issues that AI raises? Competition issues, consumer protection issues, privacy issues, security issues. And I think that the FTC is really trying to position itself as the kind of key AI regulator, given its expertise in all of these areas.
Yeah, I think that's absolutely right. And the FTC, has a toolkit that can try to achieve those goals. Now, it has limited regulatory authority over AI. It's not like Congress said to the FTC, you go ahead and you make any rules you want. It might be a better world if the FTC had stronger and easier rulemaking powers. But look, it can enforce the law against an AI company that engages in unfair or deceptive acts or practices or unfair methods of competition. Unfair methods of competition is the antitrust jurisdiction of the FTC. And the RITE AID settlement, which we're going to talk about a little bit later, is an example of the FTC using its enforcement authority. And it also has some rulemaking authority. So, for example, it's currently moving forward with, and we'll talk about this too, with a privacy and possibly AI regulation. But the FTC's rulemaking is under something called the Magnuson-Moss Act, which is a kind of medieval form of rulemaking designed to make rulemaking all but impossible. It is slow, it is cumbersome, and it's going to bump up against a very skeptical, in its most important parts, I think, it will bump up against a very skeptical and conservative judiciary. And finally, the FTC can subpoena companies to find out what's going on in an industry, to bring to light the activities of companies, and using what is known as the 6B study that's actually been in the FTC's toolkit since it was founded in 1914. Since the agency was founded in 1914. And we just saw an example of that with the subpoenas that were sent to Microsoft and Google and ChatGPT and others. What the FTC finds in that study, and we'll talk about this later too, might be the basis for legislation, but really you can't do a lot with the FTC studies, with the FTC 6B studies, except tell the public what's going on in an industry.
And if I could just pick up on one of the points that Jon just made, I think one of the key points he made is that the FTC's jurisdiction and authority is limited by Congress. And particularly in the AI space, I think one of the things that's been very interesting is we talked about the areas where the FTC has expertise, experience, jurisdiction, competition, consumer protection, privacy, security. But what I'm finding interesting is that the FTC seems to be veering outside of those areas into areas where it's traditionally had less expertise. Areas like copyright. We see the FTC weighing into the Copyright Office and providing comments about some of the issues with generative AI and copyright laws. That's not something I traditionally think of as within the FTC's wheelhouse. So I do think the FTC is kind of coloring outside the lines here. Another example is that the FTC, in kind of some of its public work, is asking questions about defamation. Again, something that's kind of taken care of through a private right of action, not something we typically see the FTC looking at. So I think the FTC is really being aggressive in pursuing its authority on AI to areas beyond its traditional experience and expertise.
Well, and that's actually a great point, Maneesha, and kind of brings me to something that I wanted to get into before we got into some of the more substantive pieces, and that was the recent summit that they hosted on AI. I believe it was last Thursday. So I'm curious, what were some of your big key takeaways there? And, did you hear any red flags for companies coming out of those discussions? I know they had some pretty robust panels throughout the afternoon. So, love to get some thoughts on, what are some of the takeaways from what we heard last week?
Yeah, sure. So I think to put the FTC summit in context, I think the FTC has done this on a few occasions where it's had a workshop or a summit where it talks about an issue, and then we can expect to see that the FTC is focusing on that issue, and it's typically a precursor to law enforcement action. So for example, back in the fall, they had this summit on content creators and generative AI. And then following that, they did this comment to the Copyright Office, and they did a staff report where they kind of weighed in on copyright issues. Similarly, from the summit last week, we saw them make an announcement about the 6B study that Jon referred to, where they're looking at the competition issues and the partnership agreements between some of the AI companies and some of the larger tech platforms. So OpenAI and Microsoft and Amazon and Anthropic, et cetera. And I think a couple of key takeaways. I think, number one is that they are very focused on the competition aspects of these deals and these partnerships and these relationships. Number two, I think we heard a constant theme from the commissioners that appeared at the conference that said, we're going to learn the lessons from the early 2000s where we let some of these companies merge and we were, for lack of a better phrase, asleep at the switch and didn't see some of the competition concerns coming. And so we're going to be more vigilant this time around. So really focused on competition. The three panels were focused on the kind of life cycle of AI, from chips and cloud to data and models to consumer applications, and looking at competition issues throughout that life cycle. You also heard some discussion of consumer protection, concerns about these companies sucking up data and creating new, what the FTC is calling surveillance models. So I think you're seeing those themes: competition, really wanting to be vigilant on competition issues, continue to be concerned about privacy. And I think it's just kind of a precursor to additional action from the FTC in this space.
Yeah, and the only thing I would add to that, and I think that's well stated, Maneesha. And I you were a terrific consumer protection lawyer at the FTC, and I had forgotten that you also had some competition knowledge as well. The other thing I would say is that the aspirations of this agency are great, but its ability to effectuate its goals is somewhat more limited. So there was a fair amount of saber rattling last week about we're not going to let this happen again. But you can't stop things unless you have the courts on your side and unless you have the law on your side. And thus far, I would say the FTC has had a mixed, not an unsuccessful as some people have said, but has a mixed record on stopping the kinds of things that it would like to stop. Think about Microsoft Activision. When the law is not strong for them, and or maybe the facts and the evidence aren't there.
Well, and speaking of saber rattling, and we've talked a little bit about it, but everybody's favorite announcement from a government agency is an investigation, and so we've got this Section 6B investigation that's been announced. I think the context is super important. So Jon, Maneesha, really curious about your thoughts about where this investigation is coming from, and should other companies be worried that the FTC can come knocking on their door?
Maybe I'll take that first and turn it over to Maneesha. I don't think if people have specific concerns about their own companies, they should talk to Maneesha. She's still in practice and she's very, very good. But I don't think so. My sense is, and it's for a couple of reasons. My sense is the commission knows exactly what it's focused on, and that is big tech getting into the business of AI. And by the way, it's already there, as we know. It wants to slow that down, or it wants to stop that. The FTC leadership believes that those corporate tech giants will diminish or choke off innovation. That would the kind of innovation that would happen if there were more smaller players and they could flourish. Plus, if you ask for, I think the number is 8 or 9 subpoenas, and I think the FTC stayed a few below that. I think it's maybe 5. If you ask for 8 or 9 subpoenas, you have to go to OMB for permission, and that is a long, having done a few 6Bs or initiated a few 6Bs, that is a long, complicated process. And so I think it's possible another company or two might get a subpoena, but I think we're very fortunate that Trustible is still a small company, because who knows? But that's going to be the extent of it. I think it's the people there. It's the focus is on the people they've already subpoenaed or sent CIDs to, civil investigative demands. Yeah,
I agree. I agree with Jon that in terms of this particular issue, I think that we're seeing the universe. For some of the reasons Jon mentioned. I do think, and just to kind of, again, put this in context, so the FTC has kind of 2 ways in which it can get information from companies on a compulsory basis. The first is this 6B, which is an industry-wide study. They're not saying like, we are investigating you in particular. We just want to create an industry-wide study so that we can kind of put out a report at the end of the process. So for example, when I was there, we did studies of data brokers. We did studies of mobile operating systems. We did studies of ISPs. And the end result is a report that puts out data on a confidential basis, so an aggregate basis of what they learned from these studies. So that's kind of the 6B authority. Where I do think that they are very focused is on the other kind of authority, which is the authority to investigate specific companies. So that is, hey, company A, are you engaged in unfair or deceptive practices, or are you engaged in unfair methods of competition? Now, those investigations are non-public until a settlement is announced. But the reason I think the FTC is really stepping up its activity in that area is because last fall, the FTC put out something, and this is very inside baseball, but it was called an omnibus resolution, which authorized the sending of CIDs to AI companies on AI issues. Now, honestly, they had the authority to issue these CIDs to AI companies anyway. I think it was almost more of a signaling that, hey, we're kind of creating this new bucket of CIDs. And so we are signaling to the marketplace that this is an area we're interested in. We're going to be sending out CIDs. We're going to be investigating companies in the AI space. And, I'm representing a number of companies in non-public AI investigations. I imagine that there will be a lot more CIDs that come out of the FTC. So I do think it's something that companies should be concerned about.
And it's an interesting point. And, I think in both of you, touched on this in your remarks, but, one of the challenges with some of these smaller AI players in the ecosystem is the unequal playing field, right? Because you do have the larger tech companies that have the resources to be able to, handle things like compute power and what have you. Are some of these activities that we're seeing, this investigation in particular, is this a step towards, promoting smaller and mid-sized AI enterprises in the ecosystem?
It sort of could be, I think, John. I think what the FTC may hope is that when it unveils its report's conclusions, and then plus a few other enforcement actions, if they can find good enforcement actions along the way, that the 6B report might lead to legislation doing exactly that. But I just want to say, we don't know what the report's going to say. Even if you have some predetermined conclusions of what you'd like to find, you always find something different and things you didn't expect. So I don't think we know exactly what the report will say, even though we have a sense of what people who initiated the report or voted for it might like it to say. You're going to have a 5-person commission. Right now, it's a 3-person commission. And so the report might be hotly disputed or carefully negotiated. And Congress, as we know, is more dysfunctional than ever. And I worked there when it was pretty dysfunctional, and it's much worse now. And so just nobody on this nobody listening to this panel should hold their breath about, the expected outcome. It is, I'm a supporter of legislation on antitrust. In the last Congress, there were great expectations that there would be major antitrust legislation or significant antitrust legislation, and it just didn't happen. So I think we should at some level, diminish our extraordinary expectations about this report. Hopefully, it will bring to light things that we did not know about AI competition and AI use.
Yeah, I would echo that. I mean, certainly on the consumer protection and privacy side, very similar situation where I think there was a hope that there would be a federal legislation on privacy. Congress came very close. But given some of the dysfunction and other factors, that didn't happen. And so I don't think we should hold our breath for privacy legislation or AI legislation at the federal level. But I do think that there are certain kind of pockets that have sprung up in terms of regulatory guidance and there's certainly the FTC has tried to step into the breach. The states are passing AI legislation, so that's something that companies need to look at. You see the executive branch coming out with the AI executive order that's requiring agencies to take certain actions. So I think there's a number of vectors of AI regulation and guidance that are coming down the pike. But I don't think we should hold our breath for federal legislation.
Yeah, that's exactly right. And of course, there are all of these different places where AI regulation and privacy regulation is moving, mostly in the states. Sometimes it's sector specific, sometimes it's broader. But privacy and AI legislation at a federal level, intelligently, crafted. And I don't think there's really a lot. I've been involved in privacy legislation for a while, and I don't think there's very much difference between what Republicans and Democrats want. Would be a much better approach. And we could do hours of seminar, hours of a webinar on that. But we can do that next time. But maybe it'll happen someday.
It's like living deja vu talking about comprehensive AI regulation. It's almost like we've heard this discussion before somewhere not that long ago. Yeah. And kind of shifting gears a little bit, but related to the various efforts that are percolating, whether at the state level or within the federal agencies, there's a lot of focus on use cases, right? That seems to be the crux of the concern. It seems to be the crux of what is attempted to be reined in. And that kind of gets us into the RITE AID discussion. But from a higher level, there's concerns around higher risk use cases, specifically in maybe this FTC context, biometric and facial recognition systems. So, curious from, kind of a broader perspective, what has the FTC, said on these things? They've weighed in before on the privacy debate and good data, practices for companies. But, in terms of, what they've said on use cases, particularly focused on higher risk use cases or, biometric facial recognition systems, like what's out there from the FTC?
Yeah, I'm happy to start with that. So I think that the FTC is really concerned about two main harms in the facial recognition biometric space. The first is what I would bucket as privacy-related harms. So the idea that maybe you're walking down the street and there's like a surveillance state that's capturing your images, or you're in a private space and there's surveillance capturing your biometric data. So I think they're concerned about having that information out there without consent. That's number one. Number two, I think the unique concern about facial recognition is that if it's being used to provide services or to kind of mark people as more risky or less risky, there's concerns about bias. So, and I think that's a lesson to all AI technology companies, is that testing for bias is very important. Testing models on for example, for facial recognition on a diverse set of faces is very important to make sure that it works, particularly if you're going to deny consumers certain benefits or mark them as shoplifters or things like that. So I don't think that concern or those harm concerns have changed in the past couple of years. I think the FTC has been very focused on that. I think what has changed is that I think it used to be the rhetoric used to hear from the FTC was all about notice and consent. Okay. So if there's a facial recognition system, consumers should have notice and they should be able to consent. But I think now, just as in other areas, the FTC's rhetoric is focused not just on notice and consent, but on having processes in place to detect bias, to mitigate against bias, to mitigate against other harms. So having processes and procedures. B, making sure that you're deleting data at appropriate intervals and not just retaining data forever. So data retention, data security, those kinds of substantive protections, in addition to the notice and consent. And then I guess the last issue I would flag in this area is one that we've been hearing a lot about from our clients since we've been hearing it from the FTC, is this issue of algorithmic disgorgement. So one of the first cases was a case that I had worked on when I was at the FTC, which was a photo sharing app where the FTC said, they would only the company said it would only exercise facial recognition or conduct facial recognition on these photos with consumers' consent. The FTC alleged they didn't get the consent, and not only did the company have to delete the photos, but the FTC had to delete the models that were created using those photos. So I think this is a huge deterrent for companies if they actually have to delete models. And I think it's really made companies sit up and take notice of the FTC more than they had before. And I think we see recent cases where this algorithmic disgorgement trend continues. I think it's a real head scratcher for a lot of companies. So, take a company that has provided a product with a huge amount of data, and maybe there was a false claim on a website, and maybe kind of 0.0001% of that data is tainted. Do they have to delete their entire model? Do they have to delete their entire business? So a lot of questions that we're getting from companies around that. But the FTC has really put a stake in the ground with this algorithmic disgorgement, and I think it's a huge game changer for companies.
Yeah, I agree with all of that. Although I would just point out that they say bad cases make bad law. And here is an example of, and it's not the first time by RITE AID, that bad corporate behavior makes good settlements or interesting settlements, because, RITE AID is a company that is now in bankruptcy. I think its stock is worth, I looked this up last night, is worth 1/1200th of what it was worth in 1999. And when we put them under order in 2010, the issue is they had taken confidential medical records, like think HIPAA, and they put them in a dumpster. At least they had done it in a couple of RITE AID stores. And here it may have been worse, right? RITE AID was using unproven surveillance or unproven surveillance system, that mistargeted potential, shoplifters and criminals, and especially minorities, and then took, interventions to sometimes remove them from stores. And so Maneesha has to grapple with this on a fairly regular basis, and Trustible may have to at some point. But you have to be careful. You have to follow the law. You have to test your systems. I don't think facial recognition systems are inherently, or they shouldn't be, inherently problematic. You just have to do them right instead of wrong. But again, this is a sort of low-hanging fruit order for the FTC. I think designed, one is to stop some bad practices, and two is to stake a claim, as we've discussed before, for AI, jurisdiction, and to be an agency that is looked to for what the rules of the road should be on AI, in the absence of and on privacy and technologies, in the absence of legislation or regulation.
Yeah, I think one additional thing just to kind of note, I think you, Jon, laid it out well in terms of like conducting risk assessments, watching claims. I think another thing that companies should take away from FTC guidance on this issue is oversight of vendors, and the need to kind of oversee vendors. Now, I think there's a lot of companies that say, well, we hired this AI company. It's a black box. They can't tell us what goes in. How are we supposed to do due diligence on that, right? But I think what we're hearing from the FTC is it's a black box isn't going to be the answer, right? That's not going to be a defense. And so, so I think the lesson here is that if you're not building the AI in-house, whether it's for a facial recognition system or any other AI system, is to make sure you're conducting the due diligence, asking the company questions, having contractual provisions in place that explain what they can use the training data for, what they can't use the training data for, monitoring those commitments. And I think that's kind of one of the main lessons from recent FTC cases.
Yeah, and look, if you're the FTC, you can preach the gospel of best practices all you want, but if you don't lay down a marker, in this case an enforcement matter, it's hard to get people's attention. This has gotten people's attention, and it should.
Well, and so you mentioned early on, Jon, the tools in the toolbox for the FTC, and Maneesha, you talked through some of the guidance that it issues. I'm curious, between this enforcement action versus a rulemaking, and specifically thinking about the commercial surveillance privacy rulemaking. What is the cost benefit, right? How is this beneficial or not as beneficial to take an enforcement action versus going through a rulemaking, where there may be a better remedy for the FTC to take when companies do something that run afoul of the law or the regulations? Just curious to get your thoughts on that.
Go ahead, Maneesha. That's fine.
Okay, so I think from the FTC's perspective, I think the cost benefit is, okay, an enforcement action can provide guidance and it's quick, and we can, there's no kind of necessarily a comment period. There is for administrative, but it's like much quicker, narrower. They can kind of have these orders that are binding on one company, but the downside is that the orders are not binding on other companies. So that's kind of from the FTC's perspective. The rulemaking, as Jon said earlier, is a very cumbersome process. So it's not like a rulemaking on COPPA, where Congress specifically gave the FTC rulemaking authority under the APA, which is notice and comment rulemaking, which you could get done in 6 months to a year.
Oh, that's very ambitious. Even when
we did it, Jon. We did it.
Say a year to a year and a half. But go ahead.
We did it when we were there in 6 months. We did one in 6 months.
One or two times with no opposition. But go ahead.
Okay. So yes, I'm the optimist. So let's say even if it takes a year to a year and a half, this rulemaking process under Magnuson-Moss, which Jon mentioned, the average time it's taken is 5 to 7 years. And that doesn't account for rulemakings that were abandoned when the administration changed. So I think the FTC has a really uphill battle in creating privacy rules through this commercial surveillance rulemaking. Now, that said, I think the FTC would have the most luck if it narrowed the rulemaking. So when it put out its advance notice of proposed rulemaking, it asked 95 questions on a range of subjects: targeted advertising, AI, data security. And I think if the FTC were to narrow its approach, I think it could be more successful in doing something more quickly. But I think we'll need to see a significant narrowing. And I do think AI is a potential candidate where the FTC might say, you know what, forget about all this other stuff. We're most interested in AI. Let's narrow the rule to be an AI rule. So I think that's a possibility. But I'm curious what Jon thinks on this.
Yeah, that's certainly a possibility. They can go in a lot of different directions. Although, my sense of this commission is it's much more of an everything, everywhere, all at once commission. And I don't think it's going to want to sort of put privacy aside and throw a curveball just to AI. It could possibly put in some interesting AI components and narrow the rule for sure. And by the way, just going back to the benefits of rulemaking, at least the way I used to think about it, is that it applies across the board, right? And it applies ex ante, not ex post, right? And so, it tells every company you must meet these standards. It makes sure that companies aren't the best companies who want to treat consumers fairly aren't at a competitive disadvantage from other companies that cheat or that immediately go to the lowest common denominator. And then I know we have a lot of corporate counsel on this call, and they're the people who say, here's what we need to do. So if they have a clear rule, they'll say we can do this, but we can't do this. And so that is a big benefit. And then from the FTC's perspective, of course, since they've more or less lost the ability to get equitable relief after the AMG decision, a rule allows the commission to get penalties for first-time violations, and that's critically important in where we are now, because Congress once again has not passed legislation to overturn or modify AMG. But I'd also say, writing these rules, particularly in the most important areas, requires meeting certain tests. Most of privacy and AI rules have to be cabined in what's known as unfairness, and that's a complicated three-part test involving substantial harm to consumers that can be aggregated. Consumers can't avoid the harm, and then a sort of balancing test on competition consumers. Is it good for competition consumers? Is it not good for competition or consumers? And so it's going to be really, really hard for the most important parts of any rule, or somewhat uphill maybe, to be approved by the judiciary. This is a judiciary. If you just look at the Supreme Court docket this year, Jarchese, relentless. It is not a Supreme Court or a judiciary that is friendly to independent agencies, executive branch agencies, and so this is going to be. They're going to have to thread a needle. Might be an AI needle, might be an AI privacy needle, but they're going to have to thread a needle to make this rulemaking successful. Though I would say, in the absence of Congress, for 10 years not doing anything, certainly since we were, and I think Maneesha, you were involved in this, our 2012 privacy report, where we called for congressional action and assumed Congress would act. It's worthwhile doing this by the FTC. Takes a lot of work, and hopefully they'll write a series of good regulations or rules, and they'll be upheld. But you never know.
So I want to be respectful of everyone's time, and I want to get some closing thoughts from the both of you, and I want to kind of bring it back to the theme of the panel, which is life after RITE AID, but it should be life after the flurry of things that have come out in the last couple of weeks. But really simple question: what should keep companies up at night in the face of some of these recent actions, between the 6B investigation, the RITE AID order? What should companies be worried about going forward?
I can start. So I think we talked about algorithmic disgorgement. I think another area that we haven't talked about as much is individual liability. The FTC has been much more focused on naming individual CEOs of companies. I think that's a potential concern. And I think just overall FTC kind of attention to all of the potential issues in the space. So I think all of that should keep companies up at night. But just to end my remarks on a positive note, I do think that there's some things that, lessons learned and some things that companies should be doing. Number one, kind of making sure they're reviewing their claims about AI, making sure they're accurate, making sure they're not doing AI washing, kind of overstating what their AI can do, et cetera. That's number one. Number two, conducting risk assessments, assessing what kinds of risks would be inherent in their particular application of AI systems, and working to address those risks. And the third thing I would say is vendor oversight. So if you can do those things, I think you put yourself in a much better position if the FTC comes calling.
And I agree with everything Maneesha just said. If companies do that, they can not only protect the entities they work for, and also protect consumers, but collectively through sort of individual efforts, we'll be able to avoid that dystopian future in which AI is so misused that bogus information isn't just a problem we have to deal with, but a part of everyday life. It's not there yet, and let's hope it doesn't. And I think companies proactively following the best guidance they can, and I think Maneesha gave a very good sort of list of that, will help ensure that it doesn't happen.
Well, really excellent insights. Maneesha, Jon, thank you both so much for taking time this afternoon to have this discussion. It's been really insightful, and I'm sure the audience is walking away thinking about some of the really great points that you made. Appreciate it again, and we will wish everybody a great rest of the day. Thank you both.
Thank you, Jon. Great job. Bye.